we're
Yes.
gonna we're gonna be starting pretty soon. Just waiting for a couple more people, so bear with me. Thank you. All right. Good afternoon, everyone. Thank you for joining me on today's Title IX committee meeting. It's been a little bit. I think the last time we met was in February. So happy to see your all faces, even though it is virtually. But I am happy to see everyone's face here, and thank you for joining us this afternoon. So I hope everyone got an opportunity to view the agenda that was sent out last week before today. It's not extremely in depth. I think with the new regulations being provided from the Department of Education, I think everyone's really eager to talk about those. So that'll be a good part about what we talk about today. In regards to the agenda, we have Dr. Burns here. I don't believe he was here in February, so I'll allow him a moment to introduce himself if you all are not familiar with him already.
Thank you, Mr. Lewis. I'm Dale Burns. I'm the interim superintendent. This is the first Title IX meeting I've had the opportunity to join. I've heard some great things about the great work that you have done over the past few months, and really have enjoyed getting to know Mr. Lewis well and the work that he's doing. As you'll learn today, there has been work done around several Title IX issues, even though we are dealing with the COVID-19 response. We're continuing to work on those important matters for the school system, including Title IX. And so thank you for letting me join you today. I'm looking forward to a good discussion.
All right, thank you. So for time purposes, we'll just go ahead and get right into it. So here I have the regulations and overview of those. So I'll talk about those in a brief moment once I get my screen up here. Can everyone see my screen?
No.
Are we good? All right. All right, so here's an overview of the new Title IX regulations. So the new Title IX regulations, they were released on May 6th, 2020. And so they have an implementation date of August 14th, 2020. What that means is that the regulations, school districts must be in compliance with these new regulations by August 14th, 2020. So that's not a ton of time. So we'll definitely be working hard to get this ball rolling to make sure that we're in a great position by the time the new school year rolls around. So overall, looking at the new regulations, I think bullet points, of course, the focus has been on making sure that we're treating parties equally during these Title IX processes, and also providing more due process as well. So in regards to some of the changes, one of the major changes is jurisdiction for Title IX cases. Of course, the Title IX of the Education Amendments Act of 1972 says no person in the United States shall, on the basis of sex, be excluded from participation in, denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So the key word in this part is. One option is Wells Fargo advisors on Houston. Is that how you're looking? Sorry, that was Siri. One of the bigger aspects of the regulation was regard to jurisdiction for Title IX cases. More importantly, about the educational program or activity. So under the new regulations, educational program or activity means any location, event, circumstances over which the recipient, which is the word that the Department of Education uses for school districts because we receive federal funding. Any of those areas where we can exercise substantial control over the respondent, the person that's been accused, and we have control over the context in which the sexual harassment occurred. So if we don't have control of the substantial control over the respondent or the context, that means it's not going to be a Title IX matter that can be resolved through the schools or district's Title IX processes. And so the way we determine that will be on a case-by-case basis. So each complaint that comes in, we'll have to look at it and first determine, do we have jurisdiction? Is there anything that the school can actually do anything about? in a Title IX matter. And also the regulations say that if we don't have jurisdiction, the schools must dismiss the complaints. And when I mean dismiss, what that means is that we cannot handle those complaints under the Title IX provisions of our student conduct policy. It doesn't mean we can't do anything about it, but we just can't handle it under the Title IX provision. So it has to be on the basis of sex, which means the sexual harassment definition, we have to have substantial control over the respondent, and we have to also have control over the context. So if it's two individuals that are students within the school system, that's pretty easy to meet control over the respondent, but the context in which it occurs will be the area where jurisdiction is most likely to be analyzed. Can we control what individuals have done off campus unrelated to school environment?
Jarrell, could you give an example of something that is out of jurisdiction?
Yes, so something that's out of jurisdiction could be something between two New Hanover County School students that happened on a Saturday in the neighborhood. Maybe there was a neighborhood fight that happened to be Title IX in nature for regard to the type of behavior, but because it was outside the school system, we don't have control over that context. So we don't have any arms that reach to a neighborhood playground on a Saturday. Versus an instance where maybe it occurred on Saturday on a neighborhood playground when the band was doing a car washing fundraiser. So let's say it happened in that context. Then that would be a little bit better argument for we do have control over that context because it's arguable that it was within a school activity, a band fundraiser, for example.
Thank you. That's clear.
Mm-hmm. So moving forward with the new regulations, there's a couple of other things that have changed. One is the definition of sexual harassment. Under the old policy, the definition of sexual harassment was generally any unwelcome conduct of a sexual nature. The new regulations actually break down what the definition of sexual harassment is. And you might have heard these terms, quid pro quo and hostile environment before. And that's because under the old regulations, quid pro quo and hostile environment were types of sexual harassment, but now they've been included and raised to be part of the definition. So number 3 is clery crimes. That is a word that is often used in higher education. And what that means is that the Department of Education has formally included the definitions of stalking, domestic violence, dating violence, and sexual assault to be incorporated within Title IX behaviors that could be sexual harassment. So since I came here in September, I've been training on definitions of stalking, dating violence, and domestic violence, moving us towards that either way. So it shouldn't be too foreign to individuals as a part of the committee. So excuse the wordiness of this slide, but there's 2,000 pages of material, so I try to get it boiled down as best as possible. So quid pro quo, I think you all know the definition of quid pro quo. With this new definition under the new regulation, the biggest change from before is that it has to be an employee that is the accused. Previously, under quid pro quo, it could be anybody that's offering some type of exchange for sexual favor for some other type of benefit, sexual benefit. It really relied on the power dynamic being there, though. Under the new regulations, they've taken away the power dynamic and have specifically inserted the word employee. So only an accused employee, for example, the teacher said, you must have sex with me, otherwise you're going to receive a failing grade. The teacher is an employee, so therefore that could be a quid pro quo complaint. If it was a student saying something like, a tutor, if you don't have this sexual relationship with me, a student tutor, if you don't have this sexual relationship with me, I'm going to try to see if I can give you a bad grade by talking with the teacher. Because as a student, it wouldn't fall under quid pro quo. So another major change is under the definition of hostile environment. Under the new regulations, the definition of hostile environment is any unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive. The key provision in this hostile environment definition is under the new regulations, the word and I highlighted, well, I underlined it there for you all. So under the old definition of hostile environment, a Title IX incident that was either severe, pervasive, or persistent and objectively offensive could raise a Title IX complaint. Under the new regulations, the conduct has to be severe and pervasive and objectively offensive. So that narrows the scope of behavior that can be a Title IX complaint. So that's the major change when it comes to hostile environment definition of Title IX matters. And in my experience, hostile environment is the type of Title IX complaint that we receive most often. For example, student says something to another student that's sexual in nature that makes them uncomfortable. That hostile environment analysis is what we would take it through to determine if there's been a policy violation.
Okay, Jarrell, I want to jump in with another question. So what happens if it's just the or, that it doesn't meet all three? Then what does the perceived person who thinks that they have been sexually harassed or whatever, what do they do then?
So now mind you, these Title IX complaints, these Title IX regulations are specific to Title IX matters only, but we still have the other provisions under the Student Code of Conduct that we can look to see these type of behaviors might violate. For example, if someone says something sexual in nature that's offensive, but it doesn't meet all three of these requirements, maybe we wouldn't call it sexual harassment because it doesn't meet these requirements, but maybe something in the Student Code of Conduct such as offensive language, something akin to cursing in class. Maybe that might be a provision under student conduct policy that we could still capture that behavior and still remedy it and discipline if need be, but we couldn't categorize it as sexual harassment, hostile environment, because it didn't match all three. And going back to earlier jurisdiction, it has to have the definition of sexual harassment has to be on the basis of sex, and it has to have control of the party and the context. So in this particular situation, if it didn't meet all three of those prongs, severe, pervasive, and objectively offensive, then it's not going to be on the basis of sex or Title IX definitions, and therefore we must dismiss that under Title IX procedures, but we can still move forward in other student conduct matters under 8410. So it's definitely going to mean that principals and are going to have to look closer at 8410 to determine if this behavior overlaps with some other provision in 8410. We can't call it sexual, but maybe we can call it something else under 8410 that would still be able to allow some type of discipline if appropriate.
Jarrell, sorry to interrupt. Are you going to, or can you share these slides with us? Because I'm thinking the Family Life Education team needs to do some revisions in the definitions that they're sharing with the students. So
yes, this will be posted on the website, and I can have this emailed out to all the members individually as well.
All right, thanks.
So moving forward, the definitions include sexual assault. What they do is allow schools to define what that means, sexual assault within their policy. Most schools generally follow state law. I don't believe North Carolina actually defines the word consent or anything like that, but we would defer to state law for the definition of sexual assault. And regard clear definitions, that just means stalking, domestic violence, and dating violence. So those definitions are included as well. So if anytime a student says, I think I'm being stalked on the basis of sex, and it meets this definition, engaging in a course of conduct directed at a specific person that would cause a reasonable person to fear for his or her safety or the safety of others, or suffer substantial emotional distress, that could put it in that bucket of Title IX area to where we could go through a formal resolution under Title IX. Dating violence, that's going to be violence committed by a person who has been in a dating or social relationship with the victim and the accused, the respondent. And the way we determine if it's a dating relationship or not is essentially on a case-by-case basis. How long have they been friends? What was the nature and context of that friendship, that relationship? Based on talking with individuals, maybe other friends that have witnessed them interacting with each other. And based on that feedback, we determine that it is some type of romantic nature, there's some type of violence, in that, then that could be an incident that gets us to Title IX. And we also have domestic violence. I think most people would know what that is, and that's mainly for higher education. So moving forward with definitions, it also talks about retaliation, and it talks about who is protected. So any individual that files a report or complaint, individual that testifies, such as a witness, assists, participates, or refuses to participate in a Title IX investigation, proceeding, or hearing is protected under Title IX retaliation. So it really protects anyone to make sure that individuals are comfortable in participating, filing a report, speaking on behalf of their personal knowledge of any incident. And so the definition of retaliation that the new regulations are using is intimidation, threats, coercion, or discrimination, including charges against an individual for code of conduct violations that don't involve sex discrimination or sexual harassment, but arise out of the same facts of circumstance. So it's pretty encompassing definition for retaliation, which is a good thing. So the new regulations also talk about mandatory reporters. The new regulations essentially tells us that all New Hanover County Schools employees are going to be considered mandatory reporters when they receive notice of sexual harassment or allegations of sexual harassment. And so what that means is that all New Hanover County employees, before it allowed individuals to, districts to choose who their responsible employees are, but now it specifically mandates for K through 12 schools that it's going to be all of your district employees. So what that would mean is that we will need to train all district employees to be able to recognize what sexual harassment is, hostile environment, quid pro quo, sexual assault, and those definitions, stalking, domestic violence. They need to be aware of what those are. So if they hear of incidents that are in that realm, or someone tells them about behavior that's in that realm, they can know, oh yes, this is my training that I received. I know that Title IX coordinator is Jarrell Lewis. I can provide the report to him, or this is the type of incidents, behavior that need to be reported.
Jarrell, could you also make note to self that it's my understanding that substitute teachers are New Hanover County Schools employees, maybe not with benefits and stuff, but that needs to be included in the substitute training as well.
Okay, so yeah, I'll have a discussion with HR regarding the scope of who is are employees and who aren't. So thank you for that note. So we can make sure that subs are included. And what I'm thinking for
also Jarrell,
go ahead.
Sorry, my dogs went flying through. Is there some other place that we're going to talk about volunteers and their requirements for reporting?
Yeah, so we definitely talk about that. And I think that in regards to volunteers and reporting, so that they're not required, but I definitely want to be more encompassing and more inclusive. So I think that having volunteers be required to report is a good thing. It's just a matter of going through how do we get those individuals trained. And I think that when we talk about the overview of our complaint resolution process, we're really doing a lot of good things when it comes to HR procedures and onboarding and things like that. I think that when we have volunteers, we can include those type of individuals in the onboarding process to make sure they get this information before they actually start participating. But these things are happening in such real time, fast time, that we will have to have some discussions on how we best accommodate that training for them. But I'm definitely not opposed and think it's a good idea that those individuals receive training as well before they interact with our students. You're muted. I think you're muted there, Stephanie.
Am I unmuted now? Okay. And I brought that up because I'm working on a committee with Ann Gibson and Caress Clegg and Stephanie Adams about the all hands on deck. And part of that, the program rollout is dealing with training of new volunteers. So that might be a good time to just wrap one of them in anyway.
Okay, thank you. And what I'm thinking about for the training, it would look like a virtual training that would probably be about 30 minutes, and they would receive it annually or whenever someone joins New Hanover County Schools as a volunteer or employee. It would be on their to-do list immediately so they can be informed of the information and what they need to do moving forward. So moving forward with the new regulations, they discussed pretty in depth about grievance procedures. What grievance procedures are is how the actual New Hampshire County Schools, how we go about resolving formal complaints. And under the grievance procedures, new regulations really talk about the separate roles for each person involved in resolving Title IX complaints. And so, for example, with roles, they talk about the Title IX coordinator being separate from the investigator, being separate from the decision maker, being separate from the appeals officer or hearing panel, and that's also being separate from support persons. So for example, the Title IX coordinator, myself, I did conduct investigations this year because there was a need for that. But moving forward under the new regulations, I will not be able to do investigations. And if I do the investigations, I'll be limited in other capacities as well. So that, for example, is a reason why we definitely have a need for the investigator for Title IX matters in central office, which we have already posted, but that's an example for district-wide complaints or those most severe allegations that shows a need because everyone will have to have a specific role. The investigator can't be the one that makes the decision. Decision maker can't be the one, and when I mean decision maker, I mean the person that determines if there's been a policy violation. The investigator cannot be the decision maker. The decision maker can't be the investigator. The person that hears the appeal, if it rises to the level of appeal, can't be an investigator or it can't be the decision maker from the initial decision. And support persons are those individuals in the role of counselors. We need to make sure that there are persons in place to just provide emotional support and really being able to walk the parties through or witnesses through these Title IX complaint processes when they do occur. So that's what the new procedures talk about. So when it comes to the beginning of a Title IX process, and when I say these procedures, I'm meaning formal complaints. So under the new Title IX process, formal complaints begin when there is actually a formal complaint. I know we have Ethics 360, so that could be an avenue for formal complaint. But also there has to be a specific request that the complainant wants the matter investigated as a Title IX matter. So these matters get into Title IX process based on the request of the complainant. I know this year, oftentimes when the Title IX incident happened, we'd automatically go into the resolution process, investigation and things like that. But now there's more of a ability for the complainant to actually make that decision. Maybe an incident happened and they don't actually want it investigate it through the Title IX process. And what that would look like, for example, we get a complaint under Ethics 360. What we would do then is contact the complainant or the parent, depending on age, and let them know what their options are. Let them know what the procedures look like. Let them know what we can do, and let them decide, is this something that they want to investigate through the Title IX process? And if they do, we initiate that process. If we don't, we'll provide support services to make them as comfortable as possible and handle it through other avenues under the student conduct process if need be. But we're really letting the complainant be in control of the direction that this process takes within reason. When there's an employee that's been accused of a matter, then we'll have to, act differently. And also depends on the seriousness of the matter as well. But generally, that's how it will operate moving forward. So when it comes to notice of allegations, when there is a notice of allegation, meaning that we're going to now tell the person that's been accused of the incident that there's been a complaint made against them. So if the complaints come through Ethics 360, the complainant has said, yes, I actually do want this to be investigated and handled through the formal Title IX process. The new regulations say that we then must provide a notice of allegations to the person that's been accused before we can do any type of initial interview with them. So that means that we have to provide some type of written notice, letting them know what the complaint is, how that might possibly violate the student code of conduct, and we have to allow them enough time to mount a defense before we can start interviewing them about what happened. Yes. I'm not sure. I can't see it.
I can't see if I'm on mute
I
either.
can hear you. You're on mute.
I'm unmuted. Okay. Am I unmuted? Okay. Okay. Say there's a witness to a some harassment, ongoing harassment, but the victim is not actually the one that makes the complaint. Does that change anything? The witness can come forward as the complainant?
So the complainant would still be the person that's actually the impacted person. So I want to actually change the definition. So in that particular instance where a third person makes a complaint, I would actually like to call that person the reporter. The person that made the complaint is the reporter. The person that's actually the impacted individual is the complainant. And the person that's been accused is the respondent. So that's how we can organize these names.
Okay.
So for example, a third party comes in, it happens all the time. Hey, my friend is being subjected to this behavior. I think there needs to be a Title IX complaint made. The third party makes the Title IX complaint, and then we go to the complainant. Hey, student C said that you might be having a problem with student B that's Title IX related. Here's what we can do. And so in that sense, what we would do then, we would contact the complainant or the parent, depending on the age, let them know we got this third party report, and then still give them the power to determine what we do with it next. That's how it would work.
Okay.
So the third party could put us on notice, but with that notice, the appropriate response would be then just to follow up. Sometimes that's happened this year already. And sometimes the complainant would say, yes, this happened to me. I want to make a report, or I don't want to make a report. And sometimes they say, no, that's not true at all. That's not anything within the realm of what's actually happening.
Mm-hmm.
And so sometimes I can create a weird position to where friend is saying this is absolutely happening to them, but the complainant, it might not want to move forward. But in that instance, we have to then make a decision how many people are involved, how many potential victims are there. Is there a way that we can move forward without this one particular complainant being active in this process? Because under these new regulations, there's a lot more due process, which means that the complainant is going to have to be in the forefront a little bit more with their involvement to get to the end and actually get to discipline if appropriate. But either way, we're going to put the ball in the hands of the complainant, even when a third-party reporter says this is happening. And what we still do is we still document those things. And so, student C comes up again in another manner, and we're seeing a pattern, then we can speak to affecting that behavior.
Right. Okay. Thank you.
Mm-hmm. So regarding the procedures, the new policies, the procedures talk about standard of proof. There's two standards of proof that can be used as either preponderance of the evidence or clear and convincing evidence. With the new procedures, schools can choose what standard of proof they use. Preponderance is the lower standard, the 51% standard. Clear and convincing is the higher standard. But whatever the district chooses for the standard of proof for the Title IX incident, it has to be consistent across the board, including employees. So that means that if we have employees policy that talks about Title IX incidents or misconduct, but it says employees are going to be subjected to a clear and convincing standard for resolution. It has to be clear and convincing that this policy was violated before we will say that an employee, before we discipline an employee. But for example, our student policy says there must be a preponderance of the evidence before we will discipline the student. That's not going to be allowed under the new policy. So we could either lower the standard of the employee provisions to preponderance of the evidence, or raise the standard of the student provisions to clear and convincing. But they must be the same. And so, talking about evidence, the burden is on the school, not the parties to gather evidence. So it's not, your complaint comes in, the school can't rely on, all right, parties, provide me all your evidence. We have to, as a school district, actively go out and try to retain any information we can and evidence from the parties. And what that looks like is the parties can suggest evidence to the schools, the investigator, but the burden is still on the school to actually do their due diligence to go out and collect as much evidence as possible, to be as knowledgeable as possible about these complaints, to make sure that we have all the information we can to properly resolve it. So also both parties must be provided the evidence once it's collected by the school. I know in some incidents, a party might say, I actually didn't get to see any of the evidence against me. Oh, that's no longer going to be able to happen moving forward. You have to share evidence with both parties equally. The way I would envision that is once the investigation has concluded the fact gathering process, the investigator would then prepare all the evidence and then provide it to each party simultaneously, whether it's through some type of electronic medium or anything like that. And then what happens then, once the parties receive physical evidence, we have to allow 10 days. And I don't know if that's 10 calendar days or 10 school days. I have to double check on that. I believe it's calendar days, but we have to allow for 10 days for the parties to have an opportunity to review that evidence. After that 10 days passes, then the parties have an opportunity to provide any type of counterpoints or any type of written response to the evidence that they will be able to have 10 days to provide any type of written response to the evidence that they've been able to review. So that allows them to have more due process, allows them more better opportunity to mount a defense, so they're not surprised. So that's an example of how due process is put into these new procedures. So moving forward.
Hey, sorry about that. The my space bar is not working to let me in. So is there somewhere in this grievance process in that 10 days where all the evidence is being collected and shared and reviewed, that there's something going on in the school system between the employee or the person who's been accused and the person who's doing the accusing, so they don't have to like sit in the same classroom for 10 days while it's all being reviewed?
Yes, and those are what we would call support services, support measures. They were previously called interim measures. So there are things that we can do that would provide the I guess, most comfortable experience or environment for the parties, even still while we're going through the investigation process. Now, mind you, with these support services, the big thing is that we cannot just operate in a manner that says if a complaint has come in against a respondent, we're going to assume the respondent is guilty, therefore student C or student B, you've been accused of incident, now we're going to make you switch from your math class because you shared a math class with the complainant. We can't automatically go from point A to point B with removal. And so there are some things I'll talk about moving forward with these new procedures. But yes, we have support services, which is why the defined roles are important. Having some advisors and support personnel such as counselors and social workers stay in those roles to provide emotional support and work with the schools to make sure that students are comfortable in the environment in the interim while their case is being investigated and handled under the formal Title IX process.
So who defines comfortable? Like suppose the complainant is not comfortable, but the accuser is perfectly fine, or vice versa?
It would be on a case-by-case basis. So it'd have to be conversations between the students, the parents, depending on the age, to really determine what the comfort level is. I've had incidents this year already to where the students were in one class and it ended up that they would switch alternate days, like an 8A, B-Day schedule for that one particular class because neither party wanted to be out of class, but we couldn't automatically presume a student to be responsible without finishing the investigation. So that's, in K through 12, it has to be really creative regarding support measures because students are in school every day, 5 days a week, sharing classes. So it really depends on open conversation and dialogue with the parties and their parents. Some students might say, this happened to me, I want to go ahead and switch to another class. That's a request, we can accommodate that. Sometimes students might not want to do that. So then that's where it gets a little bit tricky and we'll have to have honest conversations the best we can possible to meet the comfortability of each party involved without treating one party as if they're guilty for something we haven't found them to be guilty of.
Jarrell, this is Brian Martin. Can I throw a little something in here?
Yes.
So the school system, our board has made a decision that we're making some major revisions in board policies in the coming months and probably years it's going to take to do that. the State School Board Association has kind of template board policies that the vast majority of school systems in North Carolina are already using. However, New Hanover has not done that yet. However, we're moving in that direction. The State School Board Association's template policy 1710, which deals with discrimination, harassment, and bullying, has very prescribed processes for appeals if the complainant is not satisfied with the outcome. I think that in coming months, this is going to be addressed through policy, but there are very clear pathways for individuals to follow should they be dissatisfied with the findings of the investigator.
Correct. There's going to be a major policy overhaul coming in by the time August 14th rolls around. And we'll have a policy that's robust and really explains in detail to not leave any questions about how this works. So moving forward, for the sake of time, in regard to the grievance process, once parties have received evidence and provided their written report or written feedback regarding the evidence that they have read that the school system has obtained, the investigator would then move forward with their investigative report. So if a party has any type of counterpoint regarding the evidence, that gets back to the investigator. The investigator starts writing their investigative report and would include those written materials from the parties that talks about any counterpoints they have to the evidence that was collected. And then what happens then, the investigator prepares this investigative report. It's really a draft of the final decision. And so what happens after that investigative report is prepared by the investigator then sends an investigative report out to the parties. Once the parties receive it, they have 10 days to review that. And then once it's provided back to the investigator, then that evidence gathering process is done. That's going to be the report that we're using to provide to the decision maker. And then once that's done, that report is provided to the decision maker. And then the decision maker looks at the evidence that was provided in this investigative report. And then the decision maker actually determines if there's been a policy violation of 8410 or Title IX provision. And so that's how I talk about those clearly delineated roles in this procedure and these processes. And so the decision maker, which is generally for the school-based matters, is the principal. When it's an employee accused, that's generally going to be HR. And so what that will require of the decision maker is to provide a report. And what would be in that report just describes how we got to the determination that we did. It would include the allegations in the formal complaint, describe the procedural steps taken, includes the findings of facts and conclusions about the application of the recipient's code of conduct, meaning that the facts that came back in the investigation, we have to match those facts to what our code of conduct actually says. So do these facts actually violate any provisions of our code of conduct? Why or why not? Essentially show your work. And then from there, it states that the decision reached on an allegation and rationale and why. Talking about preponderance of the evidence or clear and convincing evidence, you have to talk about how we found that that burden was met. And then it talks about the procedures for an appeal. So they have to be notified of their rights and procedures for an appeal if applicable. So speaking of appeals, under the new grievance process, it talks about how appeals can look. Mind you, districts can add more rights, but we can't go under this. So it must allow for individuals to appeal, and it must allow for both parties to appeal. And the finding, I think that might be a little bit different than what we normally do. The appeal is generally reserved for the person that's been accused under our old policies. But now it can be a person that is making the complaint. If they don't like the outcome and there's a reason for them to appeal, then they can appeal that outcome as well. And so the reasons for the appeal would include a final decision on responsibility. So that could be something that they could appeal. They could appeal the dismissal to the formal complaint or any particular allegation within the complaint that can be appealed as well. The respondent can appeal that. And so reasons for appeals would include any type of procedural irregularity that affected the outcome. So something in our procedures that wasn't followed correctly, that's going to be a basis for an appeal. Maybe a party has new evidence that came out that could affect substantial material to the complaint that was not available at the time the investigation concluded its fact gathering time or process. So maybe there's been some new statement or new evidence that was found that we could not have found at the time we were collecting the evidence. Point number 3, the Title IX coordinator, investigator, or decision maker had a conflict of interest or bias for or against the complainant or respondent. And also, a recipient may also offer both parties the opportunity to appeal for other reasons, meaning that the school can add any additional reasons we want, or the district can add additional reasons. We'll still have to have that written in our policy beforehand. We just can't make it up on case-by-case basis, but we can add more appellate reasons if we decide to. So we're almost done here talking about hearings. So under the new regulations, K-12 schools do not have to provide for hearings, but we do have to have some type of mechanism that allows for the respondent an opportunity to present their side at the very least. And within that, we must allow written questions to be submitted and answered between parties. So in K-12, the policy and procedures are really worried about having a situation to where students have to be cross-examined in like a courtroom setting. In higher education, that's what they're requiring. In K-12, they're not requiring that. But at the very least, we have to have some type of mechanism to where individuals can submit written questions that can be asked of the other party, not in real time, but and through a third party that would be presenting the questions. But it still allows to get an answer, a Q&A type of back and forth if there's some type of point that a party wants to ask the other party about. So that might mean that we might need moving forward in these appeal or expulsion hearings that we might need to start inviting both parties to the hearing. They don't have to be in the same room at the same time, but we at least offer each party the opportunity to be present to state their side to the hearing panel once it gets to that point. And so talking about support measures, those interim accommodations we can provide to individuals before the case has been resolved. Those support measures must be provided as equally as possible. That situation where one student saying, I want the other person out of the classroom and things such as that, they have to be as equal as possible. So like I said, they have to be on a case-by-case basis. They can't be one-sided and they can't presume guilt. So for example, maybe let's say a high school senior is accused of a Title IX incident against with a sophomore. A sophomore female makes a complaint against a senior, a male student, but yet they're both sharing a class. And each party saying, I don't want to be moved out of this class. An example of a fair determination for how we decide who is taken out of this class would be saying, well, the senior is his only opportunity to take this class. If neither party wants to be out, we don't know if he's responsible or not. So what we're going to do is we're going to take the complainant out. But the reason we're taking the complainant out is because she's a sophomore and she has the opportunity to take the class again the next year versus the senior doesn't in the interim before we can actually get to a final resolution. So that would be an example of us using support measures fairly and neutrally as possible without presuming one side of guilt because we used some type of outside determining factor unrelated to the actual case. So that would be an example of that. A major change is also going to be interim suspensions, what they are calling emergency removal. So oftentimes these Title IX incidents can occur and the reaction is to start suspending. Well, under the new procedures, we're not going to be able to do that. Before we can remove a person from a school, suspend them, and this is before we've gotten to the actual decision-making phase, before we complete our investigation, before we determine that someone is or is not responsible, but yet there still might be a need or a want to have a student removed. There's going to have to be an individualized risk assessment, a threat assessment, before we can actually remove or suspend the person, the student or the employee as well, from the premises. And so what that means is that there has to be some immediate threat to the physical health or safety of any student or other individual arising from the allegation of sexual harassment that justifies the removal. And so what that would look like is that there's going to be a need for school districts, each individual school, as well as HR, if it's an employee, to have a team of individuals that they can gather that can go through a checklist to determine if there's an immediate threat to physical health or safety that's arising from this Title IX complaint. If there is an immediate threat, then that can be proposed to suspend the person in the interim because of the threat to health or safety. And what would happen is that team, almost like a IEP type of a determination, would have, and I'm in the process of working to create a checklist or mitigating aggravating factors list that would lead us to the decision of suspending. So it's not so arbitrary. So what would happen is if this team that's put together, the threat assessment team, decides to remove accused student or employee, what would happen is that accused student or employee would then have an opportunity to present their side to why they should not be suspended in the interim for a Title IX matter. And then once that's occurred, a decision is made whether or not to suspend the employee or the student in the interim. And so that's very different than what we've been doing before. It has to be an individualized assessment. And I'm pretty sure they didn't state this in the regulations, but I'm pretty sure they're going to want to see some type of written documentation or some type of assessment that was done, including who was there. So we're going to need to create some type of form for that. And it can only be for actual physical threats. It can't be any type of emotional harm that has occurred that would give rise to a suspension. It has to be some type of physical threat. And thinking about this past school year, I could only think of one incident to where I think that would meet the definition. And that was because the incident itself was domestic violence and there was clear physical interactions that would violate a policy in Title IX. And so that's going to be a major change. So also the new regulations specifically allow for school districts to put employees on administrative leave. It speaks to that in the regulations, but it's going to have to go through some type of individualized risk assessment as well. So talking about publishing of policies, procedures, and trainings, schools are going to have to start prominently displaying their Title IX policies, procedures, and trainings. And different areas that these things can be displayed, for example, could be our student handbooks, school websites, letters of parents at the beginning of the year, all three of those. But we're going to have to start doing that. And I think that we're going to have a link on all of our individual school web pages to the central Title IX web page. So that Title IX web page will look different moving forward. It will be more robust, more information on there. But it will also have to include the Title IX coordinator contact information, access to our policies and our procedures. That's going to have to be more prominently displayed so people can have more available access to those materials. And this is a new part in the regulations as well. Training materials. Any type of training that we conduct that's Title IX related to employees, we're going to have to make that available online via website if we have a website. We do have a website, so what we're going to have to do is post those materials to tie up all of them in fullness on the website so individuals can review that anytime. There's been some pushback in the Title IX world, particularly when it comes to copyright information. So there might be some lawsuits on that provision, but under the regulations, we're going to have to post those materials. So for example, if I do a third-party professional development as a Title IX coordinator, I have to then take those materials and post it online on our website. That might violate copyright of that third party. So there's some issues there, but that's outside of our realm, essentially. If we didn't have a website, what we could do is just make it available upon request, but we do have a website. So it's something I just wanted to add there. And this is also another major change. There's also a Title IX retention schedule. So 7 years, school districts have to keep record of all Title IX incidents. And what they're expected to include in these retention schedule would be any determination of responsibility, any audio recording, visual recording, transcripts, disciplinary sanctions imposed, any remedies provided to the complainant, talks about those support measures, any type of outcomes, things like that. Record of any appeals or anything that results in an appeal, any type of informal resolution that we put in place, such as a no contact order or class change, schedule change, We're going to have that documented and kept for 7 years. All materials used to train coordinators, investigators, decision makers, all those type of things. And any type of record of any action, including support measures taken in response to a formal complaint. So I often say in trainings, if we don't document it, it didn't happen. And under the new regulations, they're specifically saying we want to see it, and we want to see it for at least the past 7 years. So that's something that they have not ever specifically noted before. So we're about at the end here. So other information, let's talk about the implementation date of August 14th, 2020. It's a lot to get done, particularly in this pandemic, in this new state. That's something that all school districts and higher education is doing at the moment. Employee responsible for coordinating Title IX coordination for the school district. There's going to be a name change there. So under my current title, I'm technically the Title IX director. The new regulations say I specifically must be called the Title IX coordinator. Minor change, but that's something else that's in there. And so how we're actually planning to meet these new regulations is, as I think Nelson said it, or Brian, I think said it, someone said it. We have contracted with a third party that's helping us rewrite our policies and our procedures. So I've already spoken with them once. So I have another meeting tomorrow to talk about what these new policies and these new procedures look like. So NCSBA is going to help us write our policy. New Hanover County Schools, myself, will be writing the procedures, what that actually looks like. And then I'm working closely with that group to get those things written. And so I've also included a flow chart.
Sorry, go ahead.
I've also included a flow chart that explains what this procedure would look like based on the Department of Education. So if you look at the top left, so it says the school is put on notice of an alleged sexual harassment, which means they have actual knowledge. And the way that can occur is if we have, since all of our employees are responsible employees, mandatory reporters, from the cafeteria employee all the way up to the superintendent, if we hear about incidents that are sexual harassment, that means that then we do have actual notice, meaning that it's hostile environment, quid pro quo, sexual assault, domestic violence, all those definitions that we spoke of earlier. We have to actually include that as actual knowledge and move forward with our process. And so the next step is going down that second box from the far left. Does the complaint meet the standard for sexual harassment? And what that question is asking is, if the complaint comes in, so the complaint comes in, it says something happened to me, it might be sexual in nature. What we would then do is, if we would read that complaint, and we would assume that everything that's in that complaint is true. So assuming that everything in that complaint is true, would that, if true, violate a Title IX provision under our policies? If yes, that means we move forward with our process. If a complaint comes in, and if true, it would still not violate our policy under Title IX, so we have to dismiss it from the Title IX process. An example of that could be a student says, Johnny touched me inappropriately on my bottom. Of course, on my bottom, that could give rise to some type of sexual incident. If assuming all that was true, it could potentially give rise to a violation. So then for that answer would be yes, so we would move forward. So let's say, for example, the complaint said that Johnny touched me on my foot. Even assuming that was true, Johnny did that without consent, without any type of, okay, Johnny's been told several times not to do this, but he touched my foot. If that's true, then we would have to dismiss it from our Title IX process, because even if true, Johnny touching someone on the foot without consent is not going to be a violation of a Title IX policy. So that's what that definition, that box is talking about. So did the sexual harassment occur within the school's education program, and was it in the United States? That's talking about that context. So we have control over the respondent, the person that's been accused. Do we have control over the context? So it has to be within an education program. It has to be in the United States, but that's not really applicable to our school district so much. So, but those are some things that these new policies are asking us to go through before we can put it in this Title IX bucket. Because once we get into this Title IX bucket, there's a lot of things that we have to meet. So also the school, so let's say all those answers are yes. The school now has a mandatory response to investigate and provide support measures to the party. And that box says that, but in reality, what it means is that the school must then follow up with the complainant to let them know their options. And then the complainant decides, do I want this to be investigated through the formal process, or is it something that I can have resolved by just having some support measures provided to me, or maybe an informal resolution provided to me, such as maybe we mediate the problem, or maybe I'm okay if we just make sure that my seat is over here as far away as possible from the respondent's seat. So going back to the diagram, so once all that has happened, we provide support measures. The student says, I want to go ahead with the investigation. So we move forward with that investigation piece. We fact gather and we gather the evidence, and we continue to move forward from there. So then moving up towards the conclusions, even during this process, depending on the complaint, the parties could still request an informal resolution. So just because we started this formal process, it doesn't mean we have to end there. The parties could just voluntarily agree, say, hey, this is too much for me. I don't want to do this anymore. Then the school can make the determination if this complaint is something that can be resolved informally, or if it's so severe, there's so many different people involved that we have to move forward even without the complainants being present. So moving forward with the box, talks about live hearing. That's really for higher education, but then talks about the decision makers issue a written determination of responsibility. Those written determinations, those reports that I talked about earlier. And then talking about the ability to have the appeal be for both parties, whether it's the complainant appealing or the respondent appealing. That's going to be different, so that's within this process. And then once that appeal process is done, then that's going to be the conclusion of the Title IX process as a whole. So do we have any questions about what this looks like, or anything that I've discussed today?
So are we expecting that this will be on the July board agenda for first review, and then in the August agenda for approval, since school is starting on the 17th and it has to go into effect by August 14th?
I will defer to Nelson and Lisa regarding the time frame. I know first and foremost what we're doing is, I would have stopped sharing my screen. How do we do that? Anita, can you help me with this?
Mr. Bowler, let me share some information. I had a conversation with Allison Schaefer, who is head of the legal area of the North Carolina School Boards Association recently. And the person who handles the policy review work, Janine Murphy, and her staff are going through the same regulations that Mr. Lewis is going through. The district is engaged in the policy review process using the School Board Association service, and they have this at the top of their list. Given their work, what they intend to do is to provide the sample policies to districts, not just this district, but all districts as soon as possible. And once the policies are in place, and even before, in fact, Mr. Lewis can begin working on procedures, which he has done now with the flow chart and things that you see. So the time frame at this point isn't known. It is known that August 14th is a very important date, and the School Board Association is working diligently to provide the policies. I'm going to go out on a limb and make the assumption that once those policies arrive, there will be a policy committee whenever it is necessary, not just when it's scheduled, to begin that process. And the same would be true for the Board of Education.
Right. So thank you, Dr. Burns. So the question regarding time frame, it really depends on how quickly they can digest all this information and put the new policies and procedures, the model together for the school district. Like I said, I've already spoken with them last week and have a meeting tomorrow with Kristen Boyd, I believe her name is, who's doing the hands-on work for the policy specific to New Hanover County Schools. And so we're going to talk about these points of interest to them, points of interest to me regarding these policies. So I can have, even though they're not done, I can have a clear picture of where they're going, where we're going to be going, so I can get those procedures together. So I wish I could provide a better time frame besides it'll be done before August 14th. But it's a lot of material, 2,033 pages of regulation. The first regulation since 1975. So they have a number, I think up to 6 or 7 or 8 individuals combing through the policies and getting this done.
Mr. Lewis, I was going to discuss this later, but since we're talking about policy, I think it'd be a good time to discuss dissolving the policy subcommittee. A year ago, before you got here, we were in a very different place, and we really had to work quickly to get regulations in place that we felt complied fully with Title IX. Now, given the time constraints we face, we're talking August 14th. I really think it's best for the NCSBA and for you to work together to move as quickly and as diligently as possible and to make this policy a reality. I think it would be difficult to bring all those subcommittee stakeholders to the table to navigate that with all those different voices. So that would be my recommendation. I'd be curious as to your thoughts.
Yeah, the August 14th deadline is definitely going to be quickly approaching. I know I like to have collaboration and feedback and input from the community. This is what the Title IX committee is, the work that we're doing, and I appreciate the work of the policy subcommittee. But in regards to just pure time, this is going to be a major change, and the change that is being needed is very specialized. So it might not be in the best interest of time for the school district or for all the policy subcommittee members to really dive deeply into the substantive parts of these new regulations for New Hanover County, because they are so specialized and because we have this new service. It might not be the best use of our time, but I agree there. I definitely appreciate the work of the policy subcommittee. They did give us a good start and got us where we are. But these Title IX regulations are very specified, specific to what the school districts must do. So going back to the agenda, it says we are going to talk about the New Hanover County Schools complaint resolution pathways. I know there's a board meeting. It's 4:38 right now. Lisa, do you think we have time to move forward to talk about those complaint pathways, or should we table the discussion? I think you're still muted there.
Okay, I'm muted. Great. Two things very quickly. One is what I would say is in regards to the NCSBA and the policy itself, we can certainly plan and bring them in once they've had a chance to look at this. I mean, they're a very strong legal team, and I think that might be helpful to our committee. And so I would suggest maybe putting that on the agenda for a future time. I think that would be helpful to be able, so they can certainly answer the questions and how they worked through the process. But other than that, yeah, I would love to go forward and talk about the resolution pathways. I think we've got time.
All right, Brian Martin, are you with us there?
Yeah, I'm here, Gerald.
Can you speak about those new complaint resolution pathways? I know we helped put it together, so I'll give you the floor to talk about what that looks like, what work HR has been doing moving forward, because I know that's a part that a lot of individuals want to know about, what we're doing from an HR perspective.
I'm sorry, had to sign out another phone call. So the quick version is that we work with Dr. Burns and with Jarrell and with Julie Varnum, just kind of looking at how things would be addressed when concerns come in, regardless of whether they come in through E360 or whether they're coming just phone calls, however they come in. But basically, that Jarrell would kind of filter them, if you will, if they were Title IX or non-Title IX. Basically, if it relates to students, it would happen at the school level. If it relates to employees, it's going to be handled in HR. If it relates to others, then it'll be handled through Julie and her office. Jarrell, how much detail did you want to go into on this one? You're muted. Here you go.
I'm sorry, I had some technical issues on that last set. Can you repeat that last part you said to me? I'm sorry.
I just wasn't sure how far in depth you wanted to go on this. I mean, so basically we've got three possible pathways as things come in, whether it's through Ethics 360 or some other and it could go to the school, could go to human resources, or it could go through student services. And that if it has a Title IX component, then Jarrell and his office would be involved in the investigation. If not, then each of those entities would just follow their own investigative practices. Beyond that, did you want to go into any further depth on that, Jarrell?
I think that was a good overview. Thank you, and I understand the time here. So what I would just add to that is that I think the new complaint process we've had in place since the beginning of May, and I think it's been working really well. It allows us to have a sharing of evidence, sharing of complaints, I'm sorry, not evidence. So central office can be knowledgeable about the different complaints coming in through different aspects of the district. So that I think that's a strong point that we've solidified moving forward that allows us to be able to work together to pinpoint what areas and what's going on where. So yes, I receive all complaints, and then from there I send those out to the appropriate branch, being HR, student support, and that's how we're handling the complaints moving forward. So yes, thank you, Brian, for sharing that information.
And the other part of that, just the other side of it, sometimes things come directly to HR if they're employee related. And so our responsibility is to make sure that the Title IX office is aware. So for example, we had a little situation that's popped up, and I've sent that over to Jarrell today, and sent you some more stuff since then, Jarrell. So whenever you look at it, we'll talk about it. But the responsibility, as you said earlier, everyone's a reporter. So if it comes into HR and it's the Title IX, then we have that responsibility to share that with Jarrell, which we will.
Thank you. Julie Varnum, are you on the call?
I am. I'm right here.
You're a little muffled or static there, but I just wanted you to speak quickly about what training has been conducted even during coronavirus and what that's been looking like that's applicable to Title IX.
Okay, I'm sorry. I had to take my AirPods out because I could hear, but evidently you couldn't hear me.
Right.
What'd you say?
I just wanted you to briefly speak about the training that has been going on across the district that's related to Title IX, even during the midst of the coronavirus.
Absolutely. And I think Kristen is. I am. Okay, good. I thought Kristen might still be on the line. So we have been rolling out darkness to light training, and we had been working on it pretty diligently with our trainer, Tanya Jordan, who's also on the call, and also through the Carousel Center. Amy Feith is also a trainer. And prior to March 13th, we had, there were several schools that had gone ahead and signed up for their full staff training, and then several that did not get to participate prior to us basically going completely remote. And I think Kristen has the latest numbers, but as of a couple of weeks ago, when we moved it to an online platform, oh, sorry, my dog found a squeaky toy. When we moved it to the online platform, I think we had 600 or so staff that had logged on to those modules. Kristen, I think you were going to find a more updated number today.
I do. So we have had 1,443 people register for that Darkness to Light training online, and 1,340 have completed it. That's in addition to about 400 or so that we had trained prior to going remote. So we're somewhere around 1,750 people trained at this point. So that's about half of our goal. And we really focused on school staff, but of course we also roll this out to our cafeteria staff, maintenance, anybody who has any contact with students.
Thank you for those updates. So as you can see, New Hanover County Schools are definitely haven't stopped the work even during this odd time that we're all in. It's really good to hear that number is so high in regards to individuals that have been trained in Darkness to Light. Continue moving forward. I will quickly talk about one point. I know you all might be wondering what happened to the Title IX survey. So of course we were working on the Title IX survey, and we're at a point where we were prepared to release it for our middle school and high school students to get their feedback on the climate of New Hanover County schools. But then we got hit with a pandemic. So we didn't think it was best to release the survey while students weren't physically at the building in schools. So what we've done is we've tabled the Title IX survey discussions, and we'll pick those back up once we have students back in the building. So we haven't forgotten about the survey. It's just a matter of the coronavirus. So once students are back in the building, assuming back in the fall, we'll go ahead and get that ball rolling again regarding the release of the Title IX survey. So that's all that I have on my agenda. Dr. Burns, do you have any administrative updates that you want to share or anything like that?
Yes, thank you very much. And in the interest of time, I'll share one bit of information. There's been work done in the last few weeks regarding the organization in central office. And Jarrell alluded to this. Prior to the recent change, he was a one-man department, and now he is supported by Kim Joy, a paralegal and administrative assistant. And there will be an investigator position posted very soon, and that person will be hired and trained prior to the opening of school. So now Title IX is a department. It's not just Mr. Lewis doing everything by himself, which I think is great. It also means that without knowing the requirements in the new regulations, we're able to meet them by having an investigator. HR has been reorganized as well, and an investigator is imminently going to arrive on the scene. There's a recommendation tonight for a particular person to take that position. And so I'm looking forward to HR having additional support as well. And that's all I have to share this afternoon.
Thank you, Dr. Burns. Didn't we talk about our next meeting date? I'm not sure what that looks like if we're going to go ahead and schedule out. I'm not sure if we actually met during the summer or not, even during a regular time frame. So that's something we all want to talk about today, our next meeting date, or is that something we'll provide more information through email at a later date? Lisa, I'll defer to you on that.
I would say, it might be helpful to the group to get at least one update during the summer. I mean, we can. Am I still muted, or did you take me off?
Oh, we can hear you.
Thank you, ma'am. Sorry, I keep forgetting to hit that unmute button. I'm trying to think about what we're going to have over the summer. We might have another training update. You can probably talk about how we're moving through the regs and how close we get to that, and then we can certainly schedule to have the NCSBA here to talk about that process. How they see the policy being crafted. So I would say either a meeting in June or July. But I don't know that there's going to be a lot to talk about other than that, since we are moving through a lot of the goals that we had for the committee. So I don't know if anybody else had any feedback, but I would say, either or.
I would say shoot for July. I agree. I might not have a substantive update to provide because we're still in the midst of doing the work. So I would say the later months, July would be best. And that's if we've completed the work up to that point to provide an update. So we'll shoot for July, but I guess not set a date. And I'll provide an update to you, and we'll send that information out to the broader committee. So we might have a meeting in July. It just depends on where we are with this regulation update.
One thing I would like to do too is and this is something that I sort of envisioned when we started this committee, is to do a look back of where we started and where we are now. And so maybe that's something that Nelson, we can kind of put our heads together, and then Jarrell will draw you in to sort of say, okay, we're starting the timeline at the beginning of it. Let's kind of move through where we were and where we are now. I think that would be helpful, sort of encapsulate the movement through the year, a year and a half really. So I think that July would be an appropriate time to do that now that we've got the regs here.
And Lisa, I would think that during that look back, if we could have some statistics on like how many cases, that we've really looked through and gone through a semi process of whatever that process was, knowing that it's changed, just to sort of pinpoint that this was definitely needed. It's not isolated, or maybe that, we really have a handle on what's going on.
I think what we can look to, and to your point, what we can look to is we can walk through our decision points as a committee, and then look at the data that we were looking at the beginning, and then maybe what we're looking at now. So certainly we can talk about that, how to incorporate the data, and kind of the different pathways that we took as a group. So, and how we got to where we are now.
And
So.
Lisa, Janie here. Also, I'd love to share shifting boundaries. Hi. I'd love to share some of our data for shifting boundaries this year with the mapping and with the pre and post surveys. So I would love to share that in July.
Okay, that'd be great.
I think it would be excellent. Thank you.
But, and too, I think that at some point, some people are gonna, know that August 14th is a deadline. People like in the public. So it would be good for us to at least have a elevator sentence to say, this is where we are, for the August 14th, go live kind of thing. Even if it's not a lot of detail, and I'm not suggesting a lot of detail, just more the elevator. This is where you go. This is where you can see. This is what's happened. This is what will be coming. Something to that point.
Well, that's sort of the point of the look back.
Yeah.
To say this is where we started and this is where we are. So certainly we can come up with a summary statement. But Julie had prepared something a while back that she and I kind of looked at and divided it up. She had divided it up based on areas of departmental areas, training areas, and certainly we can also use that. And that was meant to be a living document. So I think we can kind of take a look at that and see, again, let's update that document and let's keep that going. And we've shared that. Julie, do you remember what board meeting that you presented that? Was that March?
Either February or March.
Yep. So we could probably continue to do an update on that and where we are as a district and the different initiatives that have been rolled out, that we're continuing to work on, the trainings that we're continuing to do, and kind of break it up per department, per area. So, yep, that's all I got. So we'll look. It sounds like we're looking at July.
Okay. All right. Well, thank you. Kim, I'll work with you and get that date solidified. I think we generally meet the second. Is it the second Tuesday of the month? I think that was our the second Monday of the month. I believe that was what it was. It's been so long, I can't remember at this point. But either way, we'll get the information out, shooting for July. So that's all that I have in regards to the agenda today. Do we have any questions or anything like that about anything I said? I know I provided a mouthful of information, so thank you all for joining. But if there aren't any questions, then I'll adjourn the meeting, but I'll sit here for an additional couple seconds to see if there are any other questions. All right, looks like there's not. Well, thank you all for joining, and stay safe. We'll be in touch.